Good morning. We're on the record. This is the recorded video deposition of Amber Laura Depp in the matter of petitioner Amber Laura Depp versus respondent John Christopher Depp II, taken on behalf of the respondent. This deposition is taking place at 2049 Century Park East, Los Angeles, California, on August 13th, 2016, at approximately 10:01 a.m. My name is Stan Beverly. I'm the videographer with U.S. Legal Support, located at 11845 West Olympic Boulevard, Los Angeles, California. Video and audio recordings will be taking place unless all parties have agreed to off the record.
Where are Charles and Manny? Okay.
Would all present please identify themselves?
Yes, good morning. Blair Burke on behalf of respondent Johnny Depp.
Hans Alhoff on behalf of respondent Johnny Depp.
Laura Wasser on behalf of the respondent Johnny Depp.
Samantha Klein on behalf of respondent Johnny Depp.
Lisa Sutton on behalf of respondent Johnny Depp.
Carrie Garbus Wright on behalf of respondent Johnny Depp.
Patty Glazer on behalf of Mr. Depp.
It being 10:02, correct? Yes. We are ready to begin, and it appears that petitioner Amber Laura Heard has not shown up for the deposition ordered by the court for today, nor has any of her legal representatives appeared. We can go off the record.
The time is approximately 10:02 a.m. and we're going off the record.
So if we
The time is approximately 10:07 a.m. and we're back on the record.
Thank you, Blair Burke on behalf of respondent Johnny Depp. It being 10:08, and we are now back on the record, having gone on the record at 10 a.m. for the court-ordered deposition of Amber Heard. Ms. Heard is apparently now here with her counsel, and if we could please have everyone introduce themselves.
Charles Harder for Ms. Heard.
Joseph Koenig for Ms. Heard.
Samantha Spector for Ms. Heard.
Pierce O'Donnell for Ms. Heard.
Leonard Levine for Ms. Heard.
I'm sorry. The certified court reporter is Pam Felton. Would you please swear in the witness?
Would you raise your right hand, please? Do you solemnly state the testimony you're about to give in this deposition will be the truth, the whole truth, and nothing but the truth?
Yes.
Good morning, Ms. Heard.
Good morning.
Ms. Heard, I'm going to be asking you some questions today. Would you prefer that I call you Ms. Heard or Ms. Depp or Amber? What would be your preference?
Ms. Heard is fine.
Ms. Heard? Okay, I will do that.
Thank you.
Ms. Heard, this is a proceeding in which you're about to give testimony, and it is known as a deposition. Do you understand?
Yes.
Okay. Our purpose in taking your deposition is to obtain the facts, the true facts and information within your knowledge related to matters involved in this lawsuit or proceeding. We did not seek to trick or to trap you in any way. We do not wish to cause you discomfort. The person transcribing the deposition is a certified shorthand court reporter. At the onset, you will be placed under oath. Do you know what that means?
Yes.
Okay. You will then be asked questions which you are expected to answer fully and truthfully. Under oath. Please do not guess. We request your best present recollection of the facts and events about which you will be questioned. We will presume, therefore, that whatever you testify to today is your best present recollection and not a guess. Do you understand?
Yes.
Okay. Although this deposition is being held in the informality of these law offices, this deposition does have all the solemnity of courtroom testimony. Since you're under oath, your testimony here today will have the same force and effect and be subject to the same penalties as if you were testifying in a courtroom before a judge. Do you understand?
Yes.
If I might ask you not to nod your head and instead answer yes or no, or however you wish to be responsive to my questions, because we have a court reporter, she needs to understand what you're saying. Do you understand?
I understand.
Okay.
You're allowed to nod your head as well as say yes if you want to.
I understood that as well. Yeah.
Among such penalties to which you are going to be subject for the penalty of perjury, I want you to know the definition of perjury. Perjury is defined as willfully and contrary to an oath administered, stating as true a material fact which you know to be false. Perjury is a crime. Do you understand?
Mm-hmm. Yes.
By saying, okay, the penalties for perjury are set forth in the California Penal Code. Everything said during your deposition will be taken down and transcribed by the court reporter. Every question we ask, every answer or comment you give, everything said by your attorney or this attorney or that attorney or that attorney or that attorney. You have, I think, 5 attorneys here. Everything said by any attorney will be duly transcribed. Do you understand?
Yes.
You've got 6 attorneys.
If therefore, I'm sorry, Mr. Hardy, did you say something?
Just noting for the record,
Noting for the record what?
how many attorneys you have and how many, or maybe you have 7.
If it therefore is vital that if any time you do not hear or do not understand any question, Ms. Heard, you tell us at once so that we may have the opportunity immediately to repeat or rephrase a question to you.
I understand.
Obviously, if you do not promptly tell us otherwise, we'll have no choice but to presume that you did clearly hear and understand each question and that your answer to each question is based upon such complete and full understanding by you.
All right, I understand.
Please also remember that the court reporter can record the words of only one person speaking at a time, so allow time for the question fully to be completed before you begin to respond. If you inadvertently are interrupted before you finish your answer, please tell me immediately. Otherwise, we will assume that your answer was complete and you had nothing further to say on the subject. Do you understand?
Yes, I understand.
And don't interrupt her also.
Let the record reflect Mr. Harder interrupted respondent's questioning to say the statement, "Don't interrupt her" also.
The record already
At the
heard it. You don't
conclusion
have
of
to
this
repeat everything
session, the
I say.
reporter will transcribe what has been said into booklet form. You will have an opportunity to read that booklet and make any changes in the form of substance of the answer to any question you feel necessary. Be advised that at the time of this trial, you will be questioned before a judge as to why you made such changes. And we will contend at trial that your memory and recollection here today are good or better than at any later time. Can you think of any reason why you would be unable to provide me with accurate and comprehensive answers today?
No, I cannot. However, I do have a question. I didn't want to interrupt you while you were saying. I have a question about
Please.
that. What do you mean by having to go back or having the option to go back and change anything I say. Why would I do that?
The
Is
reporter-
it about perhaps remembering?
Pierce's partners. One of Pierce's partners from Green Bay.
So can you please repeat that last few
Sure,
lines?
I'm happy to.
Clarify.
Thank you.
At the conclusion of this session, the reporter will transcribe what has been said into booklet form. You, Ms. Hurd, will have an opportunity to read that booklet, that transcript, and make any changes in the form or substance of the answer that you give here to any question that you feel necessary. You should know that at the time of trial, you will be asked before a judge as to why you made any changes, and our position will be that your memory and recollection today are as good or better than at any later time. Do you understand now?
Until I approve the booklet, yes. Is that the correct?
Would you like a
understanding?
moment to speak with your counsel, Ms. Hurd?
I'd just like to say something. The point is, you want to be as thorough as you can as to the question and accurate as you can, so that you don't need to make any changes. You want to be as complete in this record as possible.
Okay. All right. Thank you.
Thank you. Can you think of any reason, Ms. Hurd, why you would be unable to provide me with accurate, truthful, and comprehensive answers today?
No.
Okay. Have you ingested any alcoholic beverage in the last 24 hours?
No.
Okay. Have you ingested any alcoholic beverage in the last 30 days?
I'm going to object. I instruct you not to answer. I don't think it's relevant. I think it invades our privacy. Don't answer it.
Are you going to answer my question, Ms.
I'm
Hurd?
going to take my counsel's advice.
Okay. Ms. Hurd, have you ingested any amphetamine called Provigil in the last 24 hours?
I'm going to object, but I'll allow you to answer.
What does that mean?
I'm going to state an objection for the record. I think it invades privacy. I think it's irrelevant, but I'm not going to instruct you not to answer. It's up to you.
Saying. I take my medicine as prescribed by my doctor every day.
Does your answer mean that the truth is that you have taken the amphetamine Provigil in the last 24 hours?
I'm also going to object vague and ambiguous and assumes facts not in evidence and calls for a legal conclusion on the characterization of the medication, because you keep calling it amphetamine, but I'm not a doctor and I don't know if that's accurate or not.
I in fact don't even know what it is.
Let me assure you, Ms. Hurd, it is an amphetamine.
She was in the process
Sorry,
of...
please don't interrupt me.
Yeah, that's what I was getting at, Blair, because you instructed her to be sure to give a complete answer, but yet you're interrupting her, and that's a problem for me and for her.
Well, it's a problem for me too, so let me very clearly and unambiguously apologize to you, Ms. Hurd. I did not intend to interrupt you. I want you to be able to give full and complete statements, okay?
I would like to.
Have you taken the drug Provigil in the last 24 hours?
I have taken my medication as per my doctor's instructions.
When you refer to medication,
Yes.
is that medication to which you refer the drug Provigil?
I take all prescribed medication as prescribed to me by my doctor, and I think my medical, my medical advice from my doctor is private.
Let the record
It's not a big
reflect
deal.
that the
And any medication.
petitioner, Ms. Hurd, has not responded to the question. On behalf of Mr. Depp, we will move to strike as non-responsive.
I'm just going to object. I think your last sentence is unnecessary. I think, Blair, honestly, you're being harassing to this witness intentionally. You're trying to rattle her. whatever she says, whatever the record is, it is. You don't need to make your own commentary every time she gives an answer, and I think that's harassing and it's bothersome.
I can assure you, Mr. Harder, thank you for your comments. I can assure you I have no intention to harass Ms. Hurd. I asked her a direct question to which her response unfortunately compelled me to make an objection for the record because it was non-responsive. I will ask again, Ms. Hurd, in the last 24 hours, have you ingested the drug Provigil?
I apologize if you feel I did not answer your question. I feel as though I attempted to answer your question as best as I could while maintaining the integrity of my private medical information.
Okay, we'll just leave it at that. You've asked it 3 times.
And I also do not feel comfortable with, what, do you want me to call you Blair? I'm sorry, I didn't ask you.
That would be fine, Ms. Hurd.
Let's go with Ms. Burke.
Ms. Burke? Okay. Ms. Burke, I feel the way that you characterized it was perhaps I felt uncomfortable with how you characterized it. It's my medical history, and I feel there's something private and personal about that, and I also want to protect the integrity of my personal medical information. However, for the record, I would like to say I take my medication as prescribed by my doctor and nothing else.
Let the record reflect that on behalf of Respondent Mr. Depp, we would object. The client, the petitioner has been speaking for a number of seconds now, not in response to any question posed, and we would move to strike anything she said after the last refusal to answer the question. And Ms. Hurd, I would like to ask you about any other medications you've ingested in the last 24 hours.
Okay. Are you finished or are you going to keep? It sounded like you were almost finished and maybe you weren't. I didn't mean to interrupt.
Counsel, if you do not have an objection
Oh, I do.
or an instruction to
I
your
do.
client, could you please remain silent?
I thought you were done, Blair, and then it sounded like you maybe weren't done. I was trying to get in an objection. My objection is this. I'm going to object on grounds of privacy and confidentiality. There's not a protective order here. Her medical history is not at issue in the case. She feels uncomfortable telling you about her medical history. You may have to make a motion to compel if you want to get into medical history. I think we should just move on and let's talk about the issues in the case.
I would ask that counsel, for the record, make no speaking objections. And if there is an illegal objection, I invite counsel to make it for the record. But I would also ask, I don't want to assume, Mr. Hurd, but will you be I'm sorry, Freudian slip. Would you, for the record, would you be defending Ms. Hurd as her attorney in these proceedings?
I'm defending her right now.
Okay, I just want to make clear, I will assume that any and all legal objections will be made by you today, and not any of the other 7 lawyers.
No, you actually
here.
said earlier that all the things that everyone says on the record is going to be part of the record. So
Right, I'm asking just so that we can have a clear record and any appropriate objections can be made, that Ms. Hurd pick one lawyer from her team to defend her in this deposition and make for the record any legal objections.
Okay,
That is my request.
I understand your request. I will be making objections. If anyone else feels that they need to make an objection, I'm going to let them speak for themselves.
Ms. Hurd, have you ingested in the last 24 hours any non-prescribed medications?
No.
Ms. Hurd, have you ingested in the last 24 hours powder cocaine?
No.
Harassing.
Ms. Hurd, can you tell us, as you sit here, and let me explain. It is very common in these proceedings that we just determine whether you have had any drugs or alcohol,
Sure.
whether anything would affect your ability to tell the truth today or
Sure.
impair your ability to tell the truth, okay? So,
And she's answered all those questions. She's
Okay.
answered about medication, she's answered about non-medication, she's answered about is she capable of giving her best testimony. You've already covered all that. It's harassing at this point that you keep going over and over and over the same grounds.
Mr. Harder, are you making a legal objection?
Yes.
Okay,
It's
could you make
harassing.
that?
I said harassing, but I don't think that you got my message, so I wanted to be a little clearer.
Mr. Harder, you continue to make speaking objections which are inappropriate and improper in these proceedings. I will ask you once again to refrain from doing so. And I will ask you, Ms. Hurd, one more time to answer my question. Could you tell us if you have ingested any medication whatsoever in the last 24 hours?
Objection. Invades privacy. Confidentiality, irrelevant, harassing, asked and answered many times now. Those are all legal objections.
Ms. Burke, I feel I have answered your question. I have taken absolutely nothing that is illegal or that should impair or alter my ability to engage in and be fully present and competent during today's discussion. Sorry, can you not hear me, Blair? I just want to make sure you heard me. It seemed like you were talking. Did you hear me?
Ms. Hurd, did you receive a deposition subpoena to be at these offices yesterday at 10 a.m. for a court-ordered deposition?
What do you mean by that?
Were you aware that you were ordered by the court to be in these offices for a court-ordered deposition yesterday at 10 a.m.?
No, she didn't receive anything.
I didn't.
We went in on an ex parte application, and the court ordered it, and she was advised of the court's order. She didn't receive a deposition subpoena.
Objection. It appears that another individual representing Ms. Hurd is now
The
testifying for
individual
Ms.
has a
Hurd.
name. His name is Mr.
And
Connick.
I would ask that anything that was just said be stricken as non-responsive and move to strike as non-responsive Ms. Hurd's answer. Ms. Hurd, I asked you a question about whether you were aware you were supposed to be here in these offices yesterday at 10 o'clock for a deposition.
I'm going to object on grounds of privilege. If you learned of anything through communications of counsel, it's privileged, and I instruct you not to answer.
Ms. Hurd, can I hear your answer to my question?
I instruct you not to answer. If you learned from counsel.
Ms. Hurd, was it your understanding that you had a scheduled deposition yesterday?
If your understanding was from communications with counsel, I instruct you not to answer. It's privileged.
Ms. Hurd, did you communicate with Jody Gottlieb yesterday?
I believe I did. I believe so.
What did you say to Jody Gottlieb when you communicated with her?
I don't remember what we talked about. We talked about, we talk about many things, Jody and I.
Of the many things you talked about with Jody Gottlieb yesterday, could you tell me one thing you talked about with her?
It misstates her testimony. You can answer. Although I believe it's been asked and answered. She said, I don't recall. But if you now recall, go ahead.
I don't recall the specifics. To answer your question, Ms. Burke, I don't remember specifically what we talked about. We speak often and text often. When I say speak, I'm including text messages. I don't actually think I spoke on the phone with her. I meant I communicated with her. But I don't remember exactly about what.
Did you, do you still have those text messages?
You mean on my phone
Yes.
or on my device? I'm sure I do.
Okay. Did you bring your phone with you today?
It might be in the car.
Okay. Would you be able to retrieve your phone if we took a quick break?
I'm going to object to that.
Okay.
Let the record reflect that counsel is instructing his client not to retrieve the requested evidence.
I just said I'm going to object to that.
Ms. Hurd, did you preserve all of your communications with Ms. Gottlieb from yesterday?
Objection. Vague and ambiguous is the term preserve.
I'm happy to rephrase. Have you destroyed or deleted any of the text messaging you referred to earlier that you undertook with Ms. Gottlieb yesterday?
No.
So every communication you had with her by text is still on your phone?
What do you mean by
from yesterday?
From yesterday?
Yes.
I'm sure it is, unless, yes, I'm sure it is. I can't imagine why it wouldn't be.
I don't know what that word is. Okay. Were you informed? I'm sorry.
I was just going to ask if I could please have some water. Sorry. I didn't mean to interrupt.
Go to the water.
Are you ready to go forward?
Yes, of course.
Okay. Were you aware that you were asked to bring documents today in response to a deposition subpoena for records?
No, I was not instructed to.
Don't disclose communications with counsel.
When you say
I
you were,
have the documents.
We have
I mean,
documents.
all the documents that we're producing in connection with the notice of deposition.
Could we have them, please?
Sure.
Thank you.
Let the record reflect that I'm providing all documents that were requested pursuant to the notice of deposition for my client, Amber Hurd.
Let the record reflect that Ms. Spector provided me with about a 2-inch stack of documents that are in no particular order that I can see. We will go through them and we will determine whether they are responsive to the document production request.
Ms. Hurd, were you asked to provide any copies of text messages that you had in your possession for these proceedings?
I'm going to instruct you not to answer if you learned anything from counsel. It's privileged.
I will take my counsel's advice.
Ms. Hurd, was it your understanding that in conjunction with your deposition, your understanding, what you understood to be true, that you needed to provide the text messages between you and other people related to these matters?
If you developed your understanding from communications with counsel, it's privileged and I instruct you not to answer.
How else would I?
Did you say something, Ms. Hurd?
I said, how else would I?
Did you provide any text messages to your attorneys in response to anything that was asked of you in these proceedings?
It's privileged. Anything that you give to your attorneys, anything your attorneys give to you, words that are said, written, oral, any of that, it's all privileged. You can't answer.
I would object again to counsel testifying and continuing to articulate speaking objections. And I want to make clear, Ms. Hurd, I'm not asking about anything anybody said to you. I'm asking about what you believed you were doing and what you understood you needed to do. Did you ever have an understanding that you needed to provide texts, copies of texts that you had undertaken between you and John Depp?
It's the same question and it's the same instruction. If your understanding is based upon communications with counsel, it's privileged and you cannot answer.
Ms. Hurd, have you preserved all of your text messages in conjunction with this matter?
Objection is to the term preserved. And as to the term all and as to the term this matter, it's vague and ambiguous for numerous reasons.
Ms. Hurd, are you going to answer my question?
I would like to know what you mean. I would like to know, sorry.
No, go ahead, please.
Ms. Burke, I don't know what you mean by preserve. Because does that mean keep, save? Does it mean intentionally, unintentionally?
Very good. I want to make sure you understand what the definition of preserve is.
I understand the definition in,
Okay.
In normal context. In this specific
I meant it
one-
in normal context.
In this context, I don't actually know what you mean.
Okay.
I'm sorry.
Okay. Since you filed for dissolution from Mr. Depp on May 23rd, 2016, have you deleted any communications in text form between you and any other person?
No.
Okay. Have you, since you filed for dissolution in this matter, May 23rd, deleted any emails between you and any other person?
Yes.
Okay.
My inbox fills up, and I'm told that it is best to delete messages you don't need anymore. Everybody deletes their emails.
Have you deleted since May 23rd any emails you received or sent to Jody Gottlieb?
Not to my knowledge. I don't remember doing that.
Have you deleted since May 23rd any emails you sent or received to Raquel Pennington?
No, not intentionally, not to my knowledge. I don't remember.
When you say in response to my question, not intentionally, does that mean you may have deleted emails between you and Raquel Pennington?
I'm just going to object because I believe her answer was more than what you just said, so you're mischaracterizing her response. She said no, not to my knowledge, and then she said more. So you're leaving that part out, which I think is the first and most important part of it.
Meaning I have not deleted anything relating to this matter for any intentional purposes or reasons other than just the normal. When you are done communicating with someone and they send you an email, you don't need that email anymore and you erase it. It's space in your inbox.
Does your answer mean, Ms. Hurd, that you may have deleted emails between you and John Depp, or you and Rocky Pennington, or you and Jody Gottlieb because you felt like you didn't need them anymore?
Okay, I'm going to object. It misstates her prior testimony. It's very compound. It's vague and ambiguous.
Ms. Hurd, did you not understand my question?
No, I understood, but I agree with my counsel.
Well, if you understood my question, can you answer my question, please?
I agree. I understood your question, but I agree with my counsel and understand his advice as it relates to it.
Well, your counsel...
It's not advice, it's just an objection for the record. And it was also asked and answered. You previously asked.
I agree.
Ms. Hurd, was it your understanding that you were to provide copies of any of photographs requested?
Sorry. If you learn from counsel's privilege, instruct not to answer.
Maybe we could make a general objection that if you've heard anything or understand anything from counsel, Ms. Hurd, that you don't have to answer that question because it's privileged.
No, let's have an understanding that you're going to stop asking her for privileged information, and then I don't need to make the objection.
She's not.
Because
you need to calm down, Mr.
I'm
Harder.
fine, thank you.
Okay.
Mr. Harder looks
I am
fine.
happy to make clear that I am asking, as I have been consistently for about the last 10 minutes, Ms. Hurd to tell me about what her understanding was.
And it's privileged.
Which is clearly not privileged.
Yes, it is. If she learned from counsel, it is privileged. If you
the-
want to go to the court and brief it, we can do that. But you're asking her to give you what communications between counsel are, which develops an understanding. So that's privileged.
Ms. Hurd, were you aware that on May 20, 2016, your husband, Johnny Depp's mother died?
Vague as to time.
On May 20, 2016, were you aware that your husband, Johnny Depp's mother, had died?
So I understand. Are you asking me if I knew on that date, or if? Sorry, I'll wait till you're done.
No, you don't have to wait.
Well, it's distracting for her, obviously.
And I just want you to hear my answer.
I am listening, and I invite you to answer my question.
We'd love to. I have a question, though, so that I understand and can answer.
Maybe when we're on a break, you can ask your counsel.
I wanted to ask you a question.
Can you answer my question?
I'm trying to.
Okay, what's your question?
I don't understand what you mean.
I didn't quite get that.
So you and Siri don't understand what I mean when I ask you if you knew on May 20 that your husband's mother had died.
Are you asking me if I knew on that date, or if I know she died on that date? That's what I'm trying to clarify.
Let's start, Ms. Hurd. Did you know at any time on May 20 that your husband's mother had died?
I do not recall when I was made aware of that fact, nor do I recall what the date was that she actually passed away.
Okay.
That's why I want to clarify.
Okay. Am I correct, Ms. Hurd, that on May 20 you had already contacted a divorce lawyer?
I don't remember the date that I first contacted a divorce attorney.
And it's well.
Is it your testimony here today that you do not remember when you contacted a divorce attorney?
Yes, off the top of my head, I do not remember when the first time I contacted a divorce attorney was.
Okay. Was it before, to your memory, do you remember when you learned Mr. Depp's mother had died?
Vague and ambiguous.
I don't remember the date that I received this information. I know I learned about it from my parents on a text message, but I don't know what date that was off the top of my head.
Okay. Do you still have that text message?
I don't see why I wouldn't.
Is that yes?
It's exactly what I said. I'm sure I do. I don't know why I wouldn't.
If asked to provide that text message, would you agree to do so?
I'm going to object, don't answer, and we'll deal with it in the normal course, which is you make a request for production and then we respond to it. Anytime they ask for information, that's the protocol.
Okay. If I could ask you, if you did not delete that text message, I would ask you to keep or preserve it. Do you understand? Mm-hmm. Would you do that?
Yes.
Ms. Hurd, I want to talk to you about the events first, immediately after May 21. As you sit here today, do you have a very clear memory of the events of May 21?
Are you asking me if I have a clear memory of it?
That's exactly what I'm asking you.
Vague and ambiguous as to the year, and vague and ambiguous as to which events you're referring to, because in 24 hours, a lot of events can occur. Vague and ambiguous.
Ms. Hurd, did you understand when I said May 21 what year I was referring to?
No, not until.
Okay. Not until what?
Not until it was just made clear.
And what do you understand now after your attorney speaking I was referring to?
Yes, I am clear as to what date you mean.
Okay. And what date do I mean?
May 21st, 2016.
Thank you. Do you have, as you sit here today, a clear recollection of events on that day?
It's vague and ambiguous. It's compound. There are a lot of events that happen.
Ms. Hurd, do you remember anything that happened on May 21?
I do. I remember when Johnny smashed the phone into my face.
Objection, non-responsive, move to strike.
My
question to you was, do you remember anything from May 21? Do you?
Wait, hang on. You asked her a question, she answered it, and now you're moving to strike her answer. That's ridiculous. You can't do that.
Is that an objection, Mr.
Yes,
Hurd?
I'm objecting to you moving to strike when she gives you an answer that's responsive to your question.
Ms. Hurd, I'm asking you a yes or no question. Do you remember anything that happened on May 21st, 2016?
Argumentative and harassing.
I answered that question.
And was that yes?
I answered your question already.
Okay.
Yes.
Am I correct that on May 22nd, 2016, you signed documents for dissolution of your marriage?
Yes.
Calls for legal conclusion.
Was that yes?
Yes.
Okay. When you signed those documents for dissolution of your marriage, was that before or after you went to a birthday party?
Vague and ambiguous.
I don't remember.
You don't remember what, Ms. Hurd?
I don't remember if it was before or after the birthday party.
You went to a birthday party on Sunday, May 22nd, correct?
I did. That's Sunday. Yes, I went to a birthday party on Sunday for my friend Amanda because I was responsible for bringing her birthday cakes as per her husband's request. That was
Just stick to the question. You don't
Sorry.
need to.
But I just wanted to point out that it was my job to bring a special kind of cake.
Okay, thank you for telling me about the special cake. My question to you was, did you sign documents for dissolution of your marriage before or after you went to the birthday party?
Again, I don't remember.
Okay. What will be marked as Respondents A? Do you recognize this picture?
I do.
Okay. And is that a picture of you at this birthday party?
Yes, it is.
Okay. Do you have any cakes in your hand?
That's
In
come
this
on.
picture?
Yes.
I don't
The
know what I
picture
had.
doesn't show her hands.
It's
If you know, Ms. Hurd.
harassing.
Yes.
Harassing.
I don't know if there's cake in my hand at this moment. I do
Okay.
not.
Before,
Can't see your hand.
before you,
But the birthday party lasted for a few hours, and actually I was there for many hours, so I don't know if at what point I held cakes or.
The question was about this photo at this moment.
I remember this moment because we had to place hair over my eye to cover my black eye, and everybody at that party, 15 people at that party, 12 of
objection,
which
motion to
Stop-
strike.
stop interrupting
the witness,
I
please.
can only do one at a time.
You asked
Let
me.
her finish her answer,
You
please.
asked me specifically to not interrupt, so I would appreciate the same.
Go ahead.
I
Please,
think-
please finish your answer.
I would like to finish my answer, if that's okay.
Finish your
Thank you.
I remember this photograph because we had to place hair over my eye. The eye typically get hit on, because of the nature of, I guess would it be a right hook? But I specifically had hair placed over my eye to cover a bruise and swelling and scratches on that side of my face from the cell phone incident when Johnny smashed a cell phone into my face. So my friends here in this picture took great effort, to make sure hair was covering my eye as to not set off media attention and media storm.
Are you finished, Ms. Hurd?
Yeah. With that answer, yes?
Objection, non-responsive, move to strike the entirety of Ms. Hurd's answer.
And I'm just going to say all these motions to strike are ridiculous, and we will take them up with the court.
We'll go off the record at this time.
The question, before we go off the record, the question had
We
to.
don't have to go off the record. We have
The
to agree to go off
question
the
had
record.
to
I
do.
can only take one person at a
Understood.
time.
The question had to do with this photograph, and the answer had to do with this photograph.
We don't have to go off the record if you choose not to.
We're not going off the record. We're staying.
Okay, we'll stay here. We're still on the record.
Are you still rolling?
Yep.
All right.
Great. You're still on camera, so.
Okay. I understand. Yeah, I remember this. In
Okay,
fact, they
don't
both-
talk though.
Okay. Okay.
Love you.
All right. That's fine.
Oh.
Sure.
I know.
You're on.
Hand it to me. Hand it to me and
I know. Oh, you want me to take this?
Yeah.
I'd like to know that if I hear it, I have to write it.
And I have table mics out as well.
Oh, wow.
You
Mic
may
to the
want to
hill.
just refrain from speaking if you don't want it on the record.
We're starting now. Oh, it's here. Sorry.
Okay. Okay. Sure.
Okay. Go the 19th through the 27th.
I'm gonna check my purse.
Because the judge wanted to
Do
continue.
you guys like any water? I'm gonna get up and get one. Would you like water?
Fine, thank you. We're still on the record.
Okay, back on the record. Oh, we're still on the record. Ms. Hurd, let the record reflect that Ms. Hurd has left the deposition table, and we are still on the record.
Let the record reflect that all of the defense counsel walked out of the room for several minutes, and Ms. Hurd stepped up for less than a minute. She's coming right back
To get a water.
to get a bottle of water.
I'm sorry, I didn't mean to keep you waiting.
No
I was just
question.
doing some- Thank you.
For the record, Mr. Harder, I would like you to be aware that if this inappropriate and improper making of speaking objections continues by you, if this coaching the witness through your speaking objections and your testimony in these proceedings continues by you, we will have no choice but to stop these proceedings and seek relief from the court by filing of in limine motions.
I would just like to make clear, I have not testified at all, so what you just said is incorrect. My speaking objections are only when you are unclear about my legal objections because you keep asking the same things over and over, and it seems like I'm not being clear, and so I just want to be clear. In no way am I being obstructive at all. In no way am I interfering with your deposition at all. And I also find your questioning to be highly problematic, and I need to be able to have a clear record as to why I feel that way. And we reserve the right to file in limine motions in connection with your questioning.
Are you finished, Mr. Harder?
I am, and I think I went on about the same amount of time that you did.
Ms. Hurd, on May 22, 2016, before or after you attended the birthday party to which you referred previously, at any time during that day, did you go to the police?
No, I did not. I did not go to the police.
Okay. At the time you first filed, when did you file your action for dissolution in this case, for your divorce against Mr. Depp?
Calls for a legal conclusion.
I believe it was on. I believe it was on the following day, on Monday. But that's maybe the next day. I don't recall the exact date.
Okay. Prior to filing that action, am I correct you communicated at some point prior to the filing of that action with your publicist, Jody Gottlieb?
Vague and ambiguous.
I don't remember. I don't remember every time we text the date
Okay.
of those texts.
Okay. Do you have any of those texts with Jody Gottlieb from May 21 or May 22?
I don't know why I wouldn't.
Okay. Could you do me a favor and preserve or keep those texts for me?
Sure.
Thank you. Did you communicate? Do you remember communicating with Ms. Godley before you filed your papers in court?
Vague and ambiguous. Vague as the time.
If you say it was May 23rd, 2016, that would be Monday.
Oh, okay.
Prior to that, did you communicate with Ms. Godley about the filing of your papers?
I believe so.
Okay. What did you discuss?
I don't remember all of our discussions and what they entailed.
Okay. I hear you say you don't remember all of your discussions. Could you tell us what you do remember?
I remember having a phone call with Jody.
And do you remember what you discussed?
I remember part of what we discussed.
Could you share that with us?
I believe I called her and said, Jody, I'm going to have to file for a divorce, and I'm told that it's forced to be, or it could become public record, or it could become out in the public because of the nature of how the filing of such paperwork demands. And because I was told that there was a possibility for it to get out in the public, I needed her to know that I was going to file. And I told her, listen, I have unfortunately kept something from you, and it's something I've been dealing with for a few years. And all of those times when I would text you about falling down the stairs or having accidents, unfortunately, it's been a secret that I've been trying to fix and keep and hide to protect myself and to protect Johnny. And I've been living in this situation where I've been in a violent relationship. And all of those times when we would talk about my bruises and things like that, the black eyes, the busted lip cover-ups that we had to do with makeup, to red carpet, makeup attempts to try and hide like the scarring I got from Australia when Johnny was holding me down on the glass table with all the broken glass, and I had all these bad scars on my arms, and I was worried about that for the red carpet. I said all of those times I've been covering up this secret part of my life, which is that I've been living with Johnny, and it's been really, I've been living in a very violent relationship, and he's been hitting me. And I yesterday or day before, or some days before, Johnny came over to talk. And we were supposed to just talk about his mom. I wanted to be there, but I still wanted to have some protection from him. So I asked that Johnny come over in the daytime when it was most likely that he was sober. And he threw his cell phone into my face. And I'm going to have some markings on my face, or I have markings on my face, and I don't know how much the bruising is going to go down, but I really need to go file for a restraining order so that I can have some protection. I can change the locks. I'm told that this gives me a little bit more protection because I'm still living in his house. And she, I remember the phone call with her because she got sick to her stomach, and she said, she was at a play, and she said, I'm sorry, I have to step out. I feel sick to my stomach. And I said, I'm really sorry. I've been keeping this from you. And that's what I remember. And she said that she was really sorry that she didn't ask me more questions about all those times. And that she was there for me, and that she was giving me on the next flight home.
Okay. And this was, to your memory, do you remember if it was before or after the birthday party we referred to a few minutes ago?
Birthday party, I know, was on a Sunday. Yeah, so then it was probably maybe Sunday night, but that is my estimate. I don't have confirmation. I could probably find out for sure.
But is it fair to say, under any circumstances prior, you were having this conversation prior to the filing of your divorce action in court on Monday, correct? correct?
This conversation I had with her was before the court filing, because I think I called her to tell her.
Yes.
That I wanted her to be prepared that I was going to file, because I was anticipating that it would become public record or had the potential to become public, and I wanted her to be aware since she handles my publicity.
Okay. And so prior to when the dissolution action was filed, that was, you say Monday, you think?
I believe so. I don't recall exactly.
Okay. Would it be true to say that on Sunday, when you were having this telephone conversation with Jody, would it be accurate to say that you were petrified of Johnny?
Vague and ambiguous.
Do you understand what the word petrified means?
Yes, I understand what that word means.
I just want the truth. On Sunday, is it true to say, Sunday, May 22nd, 2016, that you were petrified of your husband, Johnny Depp?
Vague and ambiguous is the term petrified.
I would like to say that I was scared of the side. Oh, petrified is the word you would like to use?
Well, I'm only using it, Ms. Depp, because you placed it in your sworn declaration in this matter, seeking a restraining order.
Mm-hmm.
So I assumed that you understood the word. Do you understand the word?
I understand the word. Again, I answered that once, but I will answer again.
Okay.
I understand petrified.
Okay. On Sunday, May 22nd, as you were having this telephone conversation with Ms. Gottlieb, is it truthful to say you were petrified of your husband, Johnny Depp?
I was petrified of the monster, as we like to call him. Johnny and I refer to his other personality, the part of him that is present when he beats me up. That we call the monster, and have called the monster for years. And that other half of him, that other part of him, is the part of him, to whom I would say I was petrified. Of whom I would say I was petrified.
I would kindly ask you whether that answer means yes, you were petrified, or no, you were not petrified of Johnny Depp on May 22nd, 2016.
Asked and answered. Go ahead.
Okay. Again, I was petrified. Yes, I was petrified of the monster, the part of Johnny that beat me up, and did.
Okay.
On many occasions.
I just want to be clear, Ms. Hurt. Yes, you were petrified of the monster, and that monster was your husband, Johnny Depp. Is that correct?
Again, I said it was the part of him that would beat me up that I was afraid of. The other part of Johnny is a very nice guy, and one that I actually was able to live with and tried to salvage through many different attempts to get him sober, to get him help, to get his family involved, to get him clean and sober, and to protect the part of Johnny that is wonderful and is not the monster, that has blackouts and that has rage and doesn't remember and beats me up and has paranoid delusions and uses and almost kills himself when he does. That part, the one I have been trying to salvage out of him, the good part of him, is the one to whom I'm not afraid. The one I'm afraid of is the one that we call the monster. And they both reside in him.
Objection, non-responsive, move to strike. Ms.
Objection,
Hurt?
it's highly responsive, and I oppose that motion to strike.
I don't understand.
Don't worry about
Ms.
it.
Hurt?
She doesn't like your answer, so she's trying to wipe it out.
No, that I understand.
Yeah, that's all you need to know, and I'm just, for the record, I'm just letting the record know that you were responsive.
I feel I'm responding to you in the most honest way possible, and I know that it's nuanced. Human beings are nuanced and complex, and I'm speaking to you from my heart, and I apologize if it is not clear enough for you?
Just wait for a question.
Objection to Mr. Harder's testimony and statements.
Not a
And Ms.
testimony.
Hurd's last testimony and statements as non-responsive, move to strike. Ms. Hurd, on May 22nd, 2016, is it true or untrue that you were terrified of Johnny?
Asked and answered.
Can you repeat the question?
On May 22nd, 2016, is it true or untrue that you were terrified of Johnny?
On May 22nd?
Yes.
On May 22nd, I was absolutely terrified of the man that we called the monster, the version of Johnny Depp, the part of Johnny Depp that acts erratically, unpredictably, that has severe drug and alcohol problems, and that could beat me up and hurt me and not even mean to at times. That part of him I was terrified and, yes, also petrified. That part of him I became increasingly scared of because the behavior prior to May 22nd, 2016 had grown increasingly erratic and unpredictable. I was so terrified that I, days prior, went and sought advice from a friend who's lived through domestic violence as to what I could legally do to protect myself, because I lived in his house and I didn't even know if I could do something like change the locks, and I didn't know under what circumstance, what substances he was on, what particular mix or cocktail he was on, because those cocktails change quite often with Johnny, and I didn't know if this month it was cocaine and ecstasy, if it Quaaludes, or if it was other things like that. I didn't know what combo he was on, and that definitely affects the behavior of the monster of Johnny Depp. And I didn't know what he was on or what his behavior, what he was capable of doing. So the month leading up to this, because we had limited to no contact prior, I didn't know what to expect.
Let the record reflect that Mr. Harder's using his hands splayed flatly above the table to instruct the witness not to answer or to stop talking.
That's completely false. That's absolutely
I
and
agree.
completely false.
I agree. I did not actually receive any indication.
Ms. Hurd,
from
excuse me, I don't want to interrupt, but you
Go
haven't,
ahead.
there's not a question pending, okay?
Sorry. So what does that mean?
You wait for the next question.
Okay.
Okay.
So I'm not. Okay.
As to your last answer, it was non-responsive, and for the record, I moved to strike.
And that's not true, and I need to say, it was 100% responsive. The question was, were you terrified of Johnny Depp? And she gave a very thorough and articulate answer as to yes and why it was. So I completely object with your continual efforts to stop her from testifying and to wipe out what it is that she's saying.
Ms. Hurd, is it true on May 22nd, 2016, that you were, quote, in fear of Johnny terrorizing you at the Broadway penthouse?
On May 22nd, did you say?
Yes, that same Sunday we've been talking about.
I was scared of what the part of Johnny Depp that is violent and abusive could do. I was terrified of that man.
I need to take a break. My father's in the hospital and I'm getting a lot of phone calls from my family, so I need to take a short break.
Of course. Can we all remain here so we're ready to go when you're back?
That's fine, just don't ask questions.
Of
Just
course.
give
Well,
me
we'd
a
like to
couple
go off the
seconds.
record.
Of course.
Are we able to go off the record when he steps out?
No.
Okay, then take your mic off and please don't say anything.
You can walk out. You can walk out.
Okay.
May I ask,
Joe?
may we have other counsel step in? I'd
No.
like to give you as much time as
No,
possible.
we've been going on for an hour. We haven't
Yeah.
taken a break. I'm taking a break. I'm having a family emergency here. Do you understand that, Blair?
Please go and attend to it.
can use this as a bathroom break too.
Be a good idea.